You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 21, Other Patent Application Sections You Might Need. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. So this is going to be the last episode on how we write the various sections of the patent application. Listen to episode 9 through 20 to learn about each of the other sections. In the last episode, I talked about how to claim benefit of an earlier filed provisional application. That only applies if you actually filed a provisional application. If you didn't file a provisional application and there's no other related application that you filed, you can just skip that section. There are a couple of other sections that maybe would apply, but they don't apply to most of you. I'm almost tempted to say that you should skip this episode, but I think you should at least be aware of the existence of these sections. If one of these applies to you, then I'd highly recommend that you actually use an attorney and not do it yourself, because it probably means that your situation and invention are complicated enough that you shouldn't bother trying to do your own application. One section is called the Statement Regarding Federally Sponsored Research or Development. Did you come up with your invention with federal government support? If you did, then you have to include the sentence, "This invention was made with government support under," and then you identify the contract, "awarded by," and you identify the federal agency, maybe the National Science Foundation or National Institutes of Health. Then you write, "The government has certain rights in this invention." If there is no federal government support, then you don't need to include this, and for most of you, you probably don't. The next section that you might need is if you're a party to a joint research agreement. This is different than having a co-inventor. This usually applies if you're part of a big corporation or university, and there was some collaboration between the institutes to come up with the invention. This probably doesn't apply to you, and if it does apply to you, I'm pretty sure you're not writing your own patent application because these big institutions have attorneys filing their applications for them, not inventors. So you can probably skip this. Another section is called Sequence Listing, Table, or Computer Program Listing Appendix Submitted in Electronic Form. This is another section that you probably won't have, but it's possible. Sometimes your application has to have a lot of information in it that's not really practical to include in the regular filing. The easy one is the table requirement. Most of the time, you can just stick in the tables in the detailed description of the embodiments. But if you have more than 50 pages of tables, then you're supposed to submit it on a CD. Probably won't apply to you or to that many people, but you should know about it. If you need to submit a computer program and the program is 300 lines or less, you can put it directly in the application. But if it's longer than that, you have to submit the code on a CD. The sequence listing appendix on a CD only applies if you're doing biology-based patent applications and you need to include a nucleotide sequence or an amino acid sequence. If you need this, my guess is that you're at a company or university and a patent attorney will do this for you and you won't have to do it. There are some rules about how you have to do the sequencing listing on a CD and correlate that with sequence ID numbers of the written part of the application. I can almost guarantee that you'd have an attorney do this for you and you wouldn't be doing it yourself. Then there's a section called Statement Regarding Prior Disclosures by the Inventor or a Joint Inventor. This relates to whether the Patent Office can use your own work against you. Let's say you gave a presentation on January 1st, 2018 about your invention at a conference, and you filed a patent application for the same invention a month later on February 1st, 2018. That's okay to do in the US. You're allowed to file up to 1 year after you publicly disclose something. This is called the grace period, which I talked about before in a previous episode. But how is the Patent Office supposed to know that it was you that gave the presentation a month before filing and not some other person? Because some other person gave the presentation and not you, then you don't get that 1 year grace period. So this is a section where you can tell the Patent Office up front if you publicly disclose your invention, so they know that it's you that made the disclosure and they won't reject your claims based on the disclosure. That's it for all the sections of a patent application. In the next episode, I'm going to go through how you actually put all the parts of the application together for filing, such as the rules for formatting and how to order the parts in the way that the Patent Office requires. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patenting, F-O-R, inventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.